Good evening, everyone, and thank you for joining us for tonight's Hauenstein Center event. My name is Megan Radecki, and it's my pleasure to serve as the director of the Hauenstein Center. I want to acknowledge all of our members and friends and students and community who are here to join us this evening. We're really excited to be having such a great chat this evening in honor of Constitution Day and Citizenship Day. I am thrilled to be back. As some of you know, I've been out for a little bit. I am fresh off maternity leave that I was on this summer. So I have a soon-to-be 3-month-old who is currently at home missing out on this event. No offense, Dr. Muñoz, he probably would have napped through the whole thing. But nevertheless, I'm thrilled to be back. It's been a great summer, and I'm sorry to have missed the event a couple weeks ago with Victor Davis Hanson and Eric Liu, but I trust that you all enjoyed that conversation. I sure did as I zoomed in from home. But all of that is part of our larger theme for the Year of Empowered Citizenship, which we're really happy to be drawing this narrative as we look at 2024 being an election year. We think it's really, really important that each of us is reminded of the power that we hold as citizens and what our rights and responsibilities are as we show up in the world on a daily basis. Our lives have meaning and they have direct impact on the world around us. And being a new mother and staring at a tiny human every day, I am constantly reminded of that. So thank you for taking this journey with us. We have a lot of exciting programming coming up, and glad to see some familiar faces who will be with us along the way. As many of you know, we have 3 main pillars within the Hauenstein Center for Presidential Studies. We have our Hauenstein Center events, which today is, we have our Common Ground programming, where we generally pick a topic, put 2 different voices on the stage, and have them engage in civil discourse to discuss. And then we have our Peter C. Cook Leadership Academy, which is a program I'm actually a graduate of, and something that we're so proud of. As we seek to put more good humans and more leaders into the world, the Peter C. Cook Leadership Academy is really where a lot of that happens. To remind us of the Cook Leadership Academy and the good work that's being done there, we do have one of our lead fellows with us tonight who will share a leadership minute. So I want to introduce Yasmin Elamayu to you all. I'm going to read you her bio, and I have to tell you, I feel a little inept when I think about all the things that Yasmin is doing already in her young career. But we're really fortunate to have her be a part of our program, and I want to share just a little bit about her before she comes up. So, Yasmin is a second-year Cook Leadership Academy Fellow and an undergrad student enrolled in elementary education with an emphasis in applied linguistics. She's currently an ESL interventionist at a local elementary school within the Grand Rapids School District, and she spends her free time at her local refugee education center as an English tutor. Yasmin is co-founder of Educators of Color Network student organization and holds the role of community outreach coordinator. At GVSU, Yasmin is also a part of the McNair Scholars Program and the Frederick Meyer Honors College, with hopes of furthering her research revolving around linguistic discrimination and injustices within the education system. After graduation, Yasmin plans to go to graduate school with hopes of teaching internationally shortly thereafter. And with that, it's my pleasure to introduce you to Yasmin.
Good evening. My name is Yasmin Elamayu, and I am a Peter C. Cook Leadership Academy Fellow. As a first-generation American, my family's journey has been marked by resilience and a relentless pursuit of better opportunities. My parents, motivated by the promise of a better future, made the courageous decision to leave Somalia, a place they always called home. Their willingness to embrace to the unknown and adapt to a new country was a testament to their unwavering determination to provide me and my siblings with access to education and a brighter future. Their story serves as a constant source of inspiration and a reminder of the sacrifices made by families like mine in pursuit of the American dream. I will always thank my parents for their sacrifices, but it was hard maneuvering my future with no guidance and being under immense pressure as the trailblazer for generations to come. I often grappled with imposter syndrome, feeling like I didn't quite belong in academic and leadership spaces. I often had self-doubt about my abilities and whether I truly deserved to be at the university. I questioned whether I was qualified to take on leadership positions and refrained from sharing stories and that shaped who I am. It was within the nurturing environment of the Peter C. Cook Leadership Academy that I realized the significance of sharing my own narrative. I discovered that my experiences, challenges, and triumphs were not something to hide or be ashamed of. Rather, they were a powerful tool for connecting with others and inspiring change. Through the art of storytelling, I began to fully embrace my story as a leader, understanding that my perspective, shaped by my unique background and experiences, was an invaluable asset in the realm of leadership. Throughout my college experience, I encountered numerous challenges and uncertainties that tested who I am and what I represented. It was in those moments that I began to grasp the true essence of leadership. Leadership, I realized, is more than titles or positions. It's about stepping up when the need arises and empowering others and driving that positive change. I recognized that I not only had the opportunity to better myself, but also to be a role model for my family, friends, and others in my community. My name is Yasmin Alamayo, and I am a leader. It is now my pleasure to introduce tonight's speaker. Dr. Vincent Phillip Muñoz is a Tocqueville Professor of Political Science and the founding director of the Center for Citizenship and Constitutional Government at the University of Notre Dame. Dr. Muñoz received his Bachelor's of Arts at Claremont McKenna College, his Master's of Arts at Boston College, and his PhD at Claremont Graduate School. He is the author of several books and is joining us for his fourth time speaking at Grand Valley. Please join me in welcoming Dr. Muñoz to the stage.
Good evening. It's kind of like church. No one's at the front. I feel like if you wouldn't mind, I'd just yield my time to Yasmin. That was great. It's so inspiring. Thank you so much. Thank you to Megan and to Brent and to all the staff here at the Hauenstein Center for all the hospitality today. I've been here multiple times and I always look forward to it. And it's really a pleasure to be back. The work that the center does, especially with our future leaders, is so important. And it's really a privilege for me to be a small part of the programs for this fall and to help you celebrate Constitution Day. Okay, I'd like to start with two recent Supreme Court cases. The first was decided just over a year ago in June 2022. It involved a public high school football coach. His name was Joe Kennedy. Starting in 2008, Coach Kennedy started a practice of taking a knee in prayer after his team's games. Coach Kennedy teaches at Bremerton High School, a public school outside of Seattle, Washington. In 2015, so several years after he started his prayer practice, the school district found out and instructed Coach Kennedy that he needed to stop his prayer practice or at least postpone it until all the students left the stadium. Coach Kennedy didn't much like the school district's demands, and while there were some factual ambiguities when the case got to the Supreme Court, he continued to pray on the 50-yard line, sometimes with students, which led him to be suspended and ultimately relieved of his duties as a football coach. Coach Kennedy then sued. That led to June 2022's Supreme Court decision in Kennedy versus Bremerton School District. Okay, a second recent case. In 2018, the Supreme Court heard a case brought to it by Mr. Jack Phillips. Phillips, you might recall, is the Christian cake artist. That's how he describes himself, a cake artist. He owned Masterpiece Cake Shop. Phillips designed high-end wedding cakes. He refused to design a cake for Mr. Charlie Craig and David Mullins. They sought to have him design a cake for the same-sex wedding party they were going to have. Phillips refused to design the cake on account of his Christian beliefs and his beliefs against homosexual marriage. Craig and Mullins filed a discrimination lawsuit. Colorado Civil Rights Division found against Phillips. They found that Master Peak's Cake Shop and Mr. Phillips violated the Colorado Civil Rights Ordinance prohibiting discrimination, including discrimination against same-sex couples. Phillips appealed that judgment, and his case too wound up before the Supreme Court. That's 2018. So Kennedy versus Bremerton and Master Peak's Cake Shop versus Colorado Civil Rights Commission, they're noteworthy insofar as they made it to the Supreme Court. But in a way, these cases are typical of the divisions, especially the legal divisions in America regarding religious freedom and the Constitution. To speak in broad terms, and these are admittedly broad terms, but let me speak in generalities for a moment. To speak in broad terms, the progressive left embraces freedom or emphasizes freedom from religion, especially the freedom from the influence of traditional Christianity or traditional religious sexual morality. Leading progressives contend that Coach Kennedy should be prohibited from praying in front of his students, lest his players, that is the high school students, feel coerced to pray with him. They say that when state officials endorse religion, especially in the context of a public school, that can psychologically coerce students, unjustly encroaching upon the liberal conception of individual autonomy. To preserve autonomy, many progressives, not all of course, but many progressives contend that we must overcome long-standing forms of oppression, including traditional forms of condemnation against homosexuality. Whereas public school kids must be secured from unwanted prayers, the market must be made secure from invidious discrimination. The right to be free from religion means Coach Kennedy must be prevented from praying in a public high school, and Mr. Phillips must be made to design the cake. Okay, social conservatives, again, stereotyping here. Social conservatives, by contrast, say religious freedom is the freedom to be religious, especially to live and act in the public square according to one's own religious convictions. Religious liberty, many conservatives, probably most conservatives say, means that Coach Kennedy should be allowed to kneel down in prayer, even as a high school football coach, and Mr. Phillips has a right not to bake the cake. Given these seemingly contradictory commitments, freedom from religion on the one hand and freedom for religion on the other, what are we to make of our first freedom? And what, if anything, might our founding fathers have to say to us today? Does the Founders' Constitution offer a coherent understanding of religious freedom, one that we might recur to today? Is religious freedom freedom from religion or freedom for religion? My argument tonight is going to be that the founders have much to teach us, but the lessons they offer do not neatly fit into our current political categories. Freedom from religion and freedom for religion are actually both aspects of the founders' understanding of religious freedom. But the freedom our founders secured for us was more limited and more democratic than either contemporary progressives or contemporary conservatives will admit. What I'm going to argue this evening is that the founders had a robust conception, but a limited conception of the inalienable right to religious liberty. The founders conceived of religious liberty in jurisdictional terms. That is, on certain categorical limitations on state power. The founders believed that there were a few things that government could never do vis-a-vis religion, but that when government acted within its own sphere to advance the common good, religion and religious individuals could both be benefited and disadvantaged by the law. So here's what I'm going to try to do with you tonight. I should add that I'm not sure if this is a virtue or a vice. No one likes this talk, meaning, not that they don't find it interesting, I hope you find it interesting, but almost everyone disagrees with something, right? So, you can disagree too. Conservatives don't like it, they like part of it, not the other part, and liberals like part of it, not the other part. When I was drafting my book that this talk is based on, the first line in the original draft was, thank you for buying this book. No one is going to like it. The editor at the press was like, you can't start that way. Okay, one other admission here. What I'm about to do, so I'm teaching a church state class in Notre Dame right now. What I'm about to do takes me 3 weeks in my class. I'm going to try to do it in less than 30 minutes. In all of our interests, I think. I'm just going to make lots of broad assertions. I want you to know that I know I'm making broad assertions. And if you want me to focus on a particular point, please ask me to do so in Q&A, okay? Okay, so let me start with the founders' understanding of religious liberty. I don't think we understand the founders because we don't understand their basic principles of government. We've forgotten them. The founders, like us today, used the language of rights, but their understanding was arguably deeper and richer and more integrated with a robust notion of duties than our understanding today. We tend to think, not everyone, but most of us tend to think of rights in terms of interests. We say healthcare or freedom of speech is our rights because we believe in bodily health and the freedom of expression. At the same time, we recognize that even fundamental rights can be limited. Free speech can be curtailed if there's compelling governmental interest to do so. The underlying presumption in how we think about rights today is that rights come from the state, from the government. We think a good government extends rights, extensive rights, because we believe the role of government is to satisfy our collective wants and provide for our individual needs. But the extent to which any particular right is available means it has to be balanced against other rights or other interests. A process that's administered by the administrative state and finally by the judiciary. The founders had a different understanding of rights, at least when it comes to natural rights like religious liberty. Natural in this context means that the foundation of our rights lies in our human nature as created by the Creator. The natural right to religious liberty, in other words, is not granted by the government. It's a part of the natural fabric of the moral order, an order in which rights and duties are reciprocal. A just government recognizes pre-existing rights. It does not create them. The founders held that our natural rights are endowed by our Creator, not granted by the state. The founders also held that our rights were not opposed to our duties. Indeed, our duties to God is why we have rights before men. James Madison, the most philosophically articulate founder on religious freedom, stated the matter most clearly in the quote on the screen. What here is a right among men, Madison said, is a duty towards the Creator. It is the duty of every man to render to the Creator such homage and such only as he believes is acceptable to him. Because we are first and foremost children of the Creator, we have rights among men. Our first allegiance always to the Creator. Okay. The political institutions we create and the civic obligations we impose, accordingly, must recognize our pre-existing natural rights and our sacred duties. Our politics must remain limited in its aims out of respect and deference to higher claims of religious authority. I'm trying to explain the founders' understanding here. This is not my understanding, this is my understanding of the founders' understanding. We have a political right of religious liberty, again, because we have more sacred and sovereign duties to God. For the founders, then, the right of religious liberty imposes limitations on the state. The First Amendment begins, Congress shall make no law prohibiting the free exercise of religion because political authorities cannot legitimately exercise direct authority over religious exercises as such. Congress, and with the doctrine of incorporation, if that means something to you, that's great. If it doesn't, life will go on. Congress and the states lack legitimate authority to regulate any aspect of our religious worship, including by whom, how, where, and how it's performed. Government can't punish you for improper worship. It can't tell you to go to church. It can't prohibit you from going to church. It can't issue, I talked about this at lunch, government has no authority to issue preaching licenses. Why does government lack this authority? Because we, the people, never gave the government this authority. We can't give government authority over our religious exercises because our religious exercises are an inalienable natural right. We retain authority over it. We retain authority over our religious liberty because we have obligations to God. Do you see how rights follow from duties? Okay. The absence of state jurisdiction, state authority that prohibits the regulation of worship is why the founders said that government cannot establish a religion. The First Amendment has two provisions, the Establishment Clause related to religion, the Establishment Clause and the Free Exercise Clause. Both of these clauses together articulate the limits on government's authority, limits necessary to safeguard the natural right to religious liberty. We talk about, conservatives in particular talk about small government. And I said this at lunch, this will be a repetition for some of you. But small government is different from limited government. Small government just means less taxes and things like that. I mean, that's fine. But limited government means there are certain things government can't do. We're a liberal democracy, right? The word, what does the word liberal do? Well, a liberal democracy is meant to preserve freedom, right? So the aim of government is to preserve freedom. Some freedoms we never allow government to touch. The question is, why? What is it that government can never legitimately do? What grounds the limits of limited government? That's what I'm trying to explain here, at least in the founders' understanding. When the founders said Congress can make no law, Congress shall make no law in the First Amendment, they meant no law. Congress lacks authority over our religious exercises because we never gave it such authority. But this categorical character of religious liberty also means that scope is relatively narrow. When the government acts within its proper domain, religious citizens can be accommodated from burdensome laws, but they have no right to be exempted from burdensome laws. That is, as long as the government stays within its sphere, it can act for the common good. And this is my attempt to graphically portray everything I've just said over the last 15 minutes. Two spheres of authority. What goes in the alienated rights, so there's two types of natural rights, inalienable natural rights and alienable natural rights. We give government authority over our alienable natural rights to protect them. We don't give government authority over our unalienated or inalienable rights. That sounds really confusing to me. Maybe I'm tired, so maybe it makes sense to you, and I'm kind of confused. The right to revolution is an inalienable natural right. You don't go to the government to get a revolution license, right? I'll only revolt, Tuesdays and Thursdays after 9 p.m. It's nonsensical. If you understand what the right to revolution is, that is the right to overthrow a tyrannical government. If you understand the nature of the right, you understand it's an inalienable right. Everyone see that? The founders' argument is religious liberty is an inalienable right. Good so far? Okay, let me turn now to the Supreme Court's understanding of religious liberty. Whereas the founders' approach focuses on jurisdictional boundaries, marking clearly where the state lacks authority and where it has authority, the modern Supreme Court has taken on a managerial role. Rather than enforcing the Constitution's fixed rules, the modern court has sought to achieve certain results. The court has acted not as an umpire, right, calling balls and strikes on the Constitution's lines, but rather as a player in the game. And this is a bipartisan effort. Okay? The results the results the court seeks to achieve depends on who's in control. When court liberals dominated church-state jurisprudence in the middle part of the 20th century, they built a wall of separation between church and state. They read the Establishment Clause to prohibit government policies from advancing religion, even if those policies pursued otherwise legitimate civic purposes. The most famous case here is a case from 1971 called Lemon v. Kurtzman, and this is what the court said. That laws must have a secular purpose, they cannot advance religion, and they cannot entangle church from state. The particular case in Lemon it's kind of an interesting case. It comes from Rhode Island, and in the late 60s, so Rhode Island is a relatively Catholic state, at least it was at the time. And what's going on in the Catholic Church in the 60s? Well, lots of religious folks, priests and nuns, are leaving their religious orders. Well, what does that do to Catholic schools? I mean, who used to teach in Catholic schools? Well, religious sisters, nuns. And what were these religious sisters paid? Almost nothing, right? And these women are incredibly talented. I mean, you want to know why Catholic schools were so good? You have super talented women teaching for no wages. It's a recipe for really good schools, right? What happens when the nuns start to leave the church? What does that do to the schools? Well, it decimates them. So the people of Rhode Island passed legislation to supplement private education, overwhelmingly Catholic. And they said, look, if Catholic schools, or private schools, but again, mostly Catholic, if the Catholic schools use the same textbooks as the public schools, and they're teaching secular subjects like math and science, and the private school teachers make less than the public school teachers, they can get a salary supplement for the state. And what's the purpose? Well, to improve math and science education in the Catholic schools, which a significant portion of the population attended. And the Supreme Court said that's unconstitutional because it violates the wall of separation between church and state. That's the freedom from religion interpretation of the Constitution. Okay. In 1963, this also too was liberal jurisprudence, in the Free Exercise Clause, in a case called Sherbert versus Werner, again, a really interesting case, the court said religious individuals have a right to an exemption from burdensome laws. So here are the facts of the Sherbert case. Adele Sherbert, sweet old lady, she worked in a textile factory in South Carolina. This is in the late 50s and early 60s. She had worked at this textile factory for, I think, over 30 years. Textile factory got and the work week is a 6-day-a-week work week. Employees worked Monday through Saturday. Textile factory gets a new owner. Mrs. Sherbert, for years, had been working a 5-day work week because she's a Seventh-day Adventist. She had an arrangement with her employer that she didn't have to work on Saturdays. That was her Sabbath. New owners come in. They say, Mrs. Sherbert, you have to work on Saturday, just like everyone else. She says, I can't. That's my Sabbath. This is not a government agency. This is just a private employer. She doesn't show up for work. She gets a warning. She doesn't show up for work. She gets a warning. This happens 8 weeks in a row. They fire her. Mrs. Sherbert files for unemployment insurance from the state. The state denies her. The state says, well, you didn't show up for work 8 weeks in a row. You don't get unemployment compensation. Unemployment compensation is those who are fired through no fault of their own. You're not eligible. Mrs. Sherbert files a lawsuit, says, the denial of unemployment insurance from the state of South Carolina violates my First Amendment right to the free exercise of my religion. Not her employer, the state. Everyone follow? She wins. Right? The court says laws that burden religious individuals in their exercise of religion in practice are unconstitutional applied to the religious people unless there's a compelling state interest that it employs the least restrictive means. Those are legal terms. In practice, this means if you don't work because you want to go to the South Carolina football game, you don't get unemployment insurance. But if you don't work for religious reasons, you do. This is the exemption approach to religious liberty. This was the liberal approach. William Brennan, probably the most influential liberal justice in the second half of the 20th century, wrote the opinion. This is now the conservative approach to religious liberty. And in a recent case, Fulton versus City of Philadelphia in 2021, Justice Alito, in an opinion signed by Justice Thomas and Justice Gorsuch, said, we need to return to the exemption approach to religious free exercise. Okay. This is my attempt to visually depict the liberal approach and conservative approach. In the previous slide, there are two circles. In both these slides, I mean, these are separate. I really should put these on separate slides. In both the liberal approach and the conservative approach, there's only one circle. And the role of the judge is not to police the boundaries between the two circles, but to arrange things in the circle in the way that the judge thinks best. Whether to build a wall of separation or to carve out exemptions for religious believers from otherwise valid laws, both liberal and conservative judges interpret religious liberty to require special treatment for religion. Special treatment administered by the judiciary, often in a case-by-case basis using relatively vague standards. This managerial approach allows liberal judges to keep religion out of the public square whenever they deem it necessary. They use tests like government can't advance religion. It allows conservatives to do something similar with the free exercise clause. When a law substantially burdens religious individuals in practice and the state lacks a compelling interest, conservative judges can give religious believers an exemption from the law. The conservative approach effectively gives conservative judges power over religion. The liberal approach gives liberal judges power over religion. The result of both the liberal and conservative approach is that religious liberty is not treated as an inalienable right in which government has no authority, but rather an interest that judges subject to their own preferences. Both sides will either put special disability or special privileges on religion. Rather than limiting the state's authority, the state takes authority over religion and uses the Constitution to dole out special treatment. Following the framers in the natural rights philosophy on which the country was founded would lead to significantly different jurisprudential results. It would not lead to a wall of separation, nor a right to religious exemptions from otherwise valid laws. It would be, as I said earlier, much more limited. A jurisprudence consistent with our founding philosophy would prohibit government from exercising jurisdiction over religious exercises as such. As I said before, it would impose a categorical rule that government has no power or no jurisdiction over religious exercises as such. For the Establishment Clause, and this is really for the students of constitutional law and for the lawyers, but let me try to explain it in general terms. For the Establishment Clause, a natural rights approach based on the founders' political philosophy would prohibit the state from acting like a church or from delegating its authority to churches. We think liberals say if government funds religion, that's an establishment of religion. But that's not what an establishment of religion was at the time of the founding. An establishment of religion at the time, there's only one state establishment at the time of the founding. It was the 1778 South Carolina Constitution. And what they did in South Carolina, the Constitution, is once you joined a church, the church would assign pew assessments of you, taxes. They taxed church members. But those taxes were enforced by the government. That is, an establishment was when the state delegated its authority to churches. So once you became a member, the church taxed you It wasn't a voluntary agreement. The church imposed a tax on you, and you had to pay the tax. It was the delegation of state authority to churches. It wasn't government funds going to churches. That's what an establishment was. It would be a much more limited approach. The Establishment Clause would say government can't act like a church, and government can't give its power to churches. If government policy pursued a valid civic purpose, and if religious individuals or institutions qualified to participate in government programs on non-religious criteria, the founders' approach, unlike the liberal Supreme Court approach, would not read the Establishment Clause to mandate discrimination against religion. So if Catholic schools did a good job teaching math, the state could fund Catholic schools if they wanted. I'll give you a recent case example. It's called Trinity Lutheran. It's an innovative program in Missouri. So in Missouri, they're trying to figure out what to do with scrap tires, especially the big tires on semi-trucks. They're terrible for the environment. So what do you do with these tires? You can't burn them, right? It's terrible for the air. So the idea is we need to recycle tires. But what do you use recycled tires for? Anyone know what they're used for now? They're football turf and playground surfaces. That spongy black material? That's all recycled tires. So when the football players tackled, all the black stuff comes up. That's recycled tires. You don't want to eat that stuff, by the way. It's not good for you. So in Missouri, they said, if you have a school that you have an old playground that's not safe, you can apply for this scrap tire playground program. We'll take all these scrap tires and we'll resurface playgrounds, and the government will pay for it. So this church called Trinity Lutheran, right, a Christian school and church, said, we have a playground. They applied, they got the grant. And the Missouri Supreme Court said, you don't qualify because you're religious. Case gets to the Supreme Court, and the liberal justice, especially Justice Sotomayor, writes a long opinion saying, Trinity Lutheran can't get a new playground because the state must discriminate against religion. That's freedom from religion. Okay. So I said this was an older idea. It started in the 40s and 50s, but it's still present in some judges' mind today. Okay, so that's the Establishment Clause. The founder's position is Trinity Lutheran can, if they qualify for the program, they get the program. It doesn't matter if they're religious, as long as the program itself has a civic purpose. Keep kids safe. So everyone is treated equally before the law. The same would be true for the Free Exercise Clause. Following the founders would only mean that government could not punish or prohibit or command individuals for their religious exercises as such. Government can't punish you for praying. Government can't punish you for not praying. Government can't punish you because it can't take notice whether you pray or not. That's the founders' understanding of the right to free exercise. The right to free exercise doesn't mean you get an exemption from the law if you're religious and you find it burdensome. Just as liberals would give religion special privileges, special disabilities, conservatives want to give religious individuals special privileges. The founders' approach is equality before the law. Now, the founders recognized that the rule of law is not perfect and that in some circumstances, exemptions from generally applicable laws might be necessary. The classic example is Quakers and military service. Right? Quakers are pacifists. Can we draft Quakers? And the founders' answer is, yes, we can, but we can also give the Quakers an exemption. Think about it for just a second. What is the political community? The first thing the political community is, it's a mutual defense pact, right? I won't harm you, you don't harm me. We'll fight for each other against those people who will harm us. The political community is much more than that, but at its essence, that's what it is. It's a community for safety. Again, it's more than that, But at its essence, that's what it is. This is why when law enforcement acts badly, when police officers act badly, if you believed that the police would not protect you and your family, what would you do? What's your first instinct? In fact, if you think if you call the police might harm you, what's your first instinct? What was that? Well, don't call them, and who's going to protect you? And how are you going to protect yourself? You're going to arm yourself, aren't you? You're going to go back into a state of nature where every man, every family is for himself. We form the political community for protection. This is why police corruption is so damaging to the fabric of the community. Okay, we form the community for mutual protection. I'll fight for you, you fight for me. What about those who don't want to fight? Says, well, I can't fight. This religious pacifists, or today we'd say conscientious objectors. And the founders' approach was, everyone has the same obligations of citizenship, but we, the community, can grant exceptions if we deem it necessary or desirable, but no one has a right to an exemption. Exemptions were legislative and discretionary, not a matter of constitutional right. Okay. Go back to our circles. I should start to wrap up here. The founders' natural rights approach draws relatively clear lines concerning religious worship and state power. It would have the judiciary police these lines. The judicial question would be, does the state authority to have authority to act in this way? Not, is the legislature benefiting or harming religion? Right? Okay, a few words of the advantages of the founders' approach. Court liberals seek to prevent religious individuals from participating in our civic life on equal terms. They unjustly penalize religious citizens to advance an exaggerated notion of freedom from religion. Court conservatives seek to exempt religious individuals from the civic obligations of following duly enacted laws. They privilege religious citizens to advance an exaggerated notion of freedom for religion. Adopting the founders' approach certainly would not satisfy everyone. As I said, it would probably satisfy no one. Liberals would have to accept that freedom from religion means that one cannot be coerced to going to church, not that one can eliminate the presence of religion in the public square. Conservatives would have to accept that religious freedom only means that government cannot impose targeted disabilities on religious exercises, not that religious individuals are entitled to exemptions from otherwise valid laws. It's probable that the founders' approach would appeal to no one. But if we think about it, what would it require? It would emphasize legislative compromise. It would downplay the role of the judiciary, and it would especially downplay the role of special interest law firms. The people who hate this lecture the most are lawyers. The founders' approach would leave things up to the people, whereas the current approach, whether liberal or conservative, turns things over to the judiciary. And who has most influence among the judiciary? The current approach empowers lawyers, not citizens. In the founders' approach, religious and non-religious citizens would have to learn to get along better and attempt to work together to adopt laws that in justice can apply to everyone. Social conservatives would have to focus on preventing laws that they find oppressive, not getting exemptions from them. It is possible that the founders' approach would only inflame more political disagreement, and that religious and non-religious citizens today are so far apart that the best we can hope for is for each side to vigorously advance its own interests And sooner or later, one side will defeat the other side in court. But the winner-take-all approach hasn't really worked so far. It is simply not healthy when, depending on who we elect in 2024, the meaning of our Constitution changes. We will no longer respect the Constitution if we think we can simply change it every time we vote. That's in no one's interest, not if you believe in the rule of law. Okay, let me finish up here. If we followed the founders, Jack Phillips would not receive a constitutional exemption from the Colorado anti-discrimination law. If the people of Colorado say to do business in the state, you can't discriminate, then anyone who runs a business has to not discriminate. Religious conservatives who think Jack Phillips should be able to serve or not serve whomever he likes, they would have to make the argument and persuade their fellow citizens that the extension of non-discrimination laws actually produces unfair discrimination against certain business owners. Think of how they might make that argument. Instead of appealing to their own narrow religious convictions, they might say to liberal small business owners, imagine you're a gay couple and own a custom t-shirt printing business. Should you have to print t-shirts that have a message with which you disagree? Or you're a gay couple and you own a catering business. Should you have to cater the church picnic for a church group with whom you vehemently disagree? Instead of appealing to narrow self-interest, conservatives would have to appeal to the common interest of business owners. That argument may or may not be successful, but you see how it engages fellow citizens in a different way and tries to build common ground among common interests to attempt to pass laws that can apply to everyone the same. Some of you might recall that this is the exact argument of Federalist Paper number 10 and how the multiplicity of interests leads to better laws. In short, if religious citizens or any citizens think the law would be oppressive when applied to them, they would need to be more political and less legalistic. They would have to attempt to persuade their fellow citizens why such laws are bad, not secure exemptions from such laws. Okay, what about Joe Kennedy, the football coach? If the school district does not generally regulate coaches' behaviors, expressive behaviors after games, you can't just regulate religious behavior. Think of what would happen if Joe Kennedy took a knee after the game to protest injustice more generally, or societal discrimination. Would he have been fired? The answer clearly is no. If you don't regulate your coach's behavior, and no school district does, you can't say you can do anything but take a knee in prayer. For the founders, religious liberty didn't primarily mean freedom from religion or freedom for religious individuals to be exempt from otherwise valid laws. Religious liberty for the founders meant that the individuals of any and all or no religion could be fellow American citizens. Religious freedom meant that all religious citizens would be treated the same as non-religious citizens, equal under the law. It meant that government could not target religious exercises. You can't criminalize religious behavior or the lack thereof. And it respected our natural right of religious liberty, which again follows from the duty to worship the Creator according to our own conscience. We haven't followed the founders really ever in our jurisprudence. I've tried to convince you that at least we should understand them, and if we understand them, they might have something to teach us today. Whether or not it's meritorious to follow the founders really should be something we talk about together. So let me conclude and thank you for your attention. Thank you very much. I think we have, I'm sorry, I kind of went on and on. I apologize for that, but we have some time for Q&A, I think. So It would help me if you just introduced who you are and where you are at the university or in the community. Happy to take any or all questions.
Hi, I'm Nick Cox, just a member of the community. In the Bill of Rights, freedom of speech, freedom of assembly, freedom of the press, all of them have some limit that is put on reasonable. Okay, mm-hmm. And I would argue that freedom of religion, if one conspires that polygamy or human sacrifice is a part of their rightful religious practice, society somewhere draws a line in terms of the common good. How is that determined where that line happens, given the founder's interpretation of inalienable right?
Yeah, that's a wonderful question. I know how to give a 20-minute answer. I'm trying to figure out if I know how to give a 2-minute answer. Let me try to give a 4-minute answer. Okay. Literally, I just gave a 45-minute lecture on this in class on Monday. All natural rights have natural limits. Here's the thing. We don't understand what it means to possess a right. This is the fundamental thing. Let me give you a simple example. We say we have the right to free speech. Does that mean you can say anything you want about anyone? Can you say untrue things about someone? Like tomorrow, can you go out and say Professor Muñoz's lecture was horrible? Sorry, yes. You could say that, but yeah. Can you slander someone? No. Why not? You can't say maliciously false things, knowingly say maliciously false things about someone. That's called slander. It's subject to civil and criminal liability. And we say, well, that's an exception to free speech. That's not an exception to free speech. Free speech doesn't include the right to slander. It doesn't include the right to morally offensive pornography. Another example. What day of the week is it? It's Tuesday, right? Tuesday. When is it reasonable? So you have your backyard, right? The students, they go to a lecture. What do you do after the lecture? At Notre Dame, the weekend starts on Thursday. So Thursday night, the students who live off campus, they have a party in their backyard. Can they make as much noise as they want in their backyard all hours of the night? I mean, it's their backyard. Say they own the house. And the answer is no. At some point, the neighbors can come over and say, be quiet. We all understand that, right? We all understand that we have freedom, but our freedom is bounded. The way the founders talked about it is they say you have natural rights, and your natural rights are bounded by the natural law. You can't lie about someone. You can say what's true. You can't use your property in ways that cause harm to others. That's called a nuisance, right? Right? You can't put contaminants in your backyard that will leak to the common ground, leak under the fence or leak into the river. We all understand this. A right doesn't mean you have a right to do anything. A natural right means you have a right to exercise your freedom within the natural moral law, which the gentleman said, you have a right to reasonable behavior. Then the question is, what is reasonable? That's the job of the legislature. So in my backyard example, look, if there was no law, and I had my backyard and you had your backyard, it would be reasonable that I can do whatever I want in my backyard, but I can't use my backyard in such a way that it disturbs you unreasonably. I can't have a party on a Tuesday night at 2 o'clock in the morning. But my kids can play loudly at 2 p.m. in the afternoon. Everyone understands that. The question is, what time do I have to be quiet? Is it 9 p.m.? Is it 10 p.m.? Is it 11 p.m.? Everyone agrees with the principle, don't use your backyard in a way that is noxious to others. What we disagree about is the particular. I say 9, you say 11. And so we form a political community and we give authority to the legislature to make that law. And we all agree, we get a voice in making the law, and we all agree to live according to the law. And the purpose of the law is to facilitate the exercise of our freedom. So we all know the rules. You can be loud in your backyard until 10 p.m. So the people, through the legislative process, draw those lines. That's the way our system's supposed to work. The way it works today, who does draw those lines today? Judges. And who has most influence over judges? Lawyers. And those who can hire expensive lawyers. And that's why the people don't govern themselves. I'm just explaining one small component of how we, the people, have lost authority to a class that can afford very expensive lawyers. And I could multiply it over and over and over again. Other questions? Gentleman right here.
Good evening. Thank you for coming today and speaking.
Yeah.
My name is Javon Fields. I'm a political science major at Grand Valley State University. I'll keep my questions brief. It's two-part, though. So how does a state recognize a religion?
Yeah.
And what is the process of a state recognizing a new religion?
Jay, is that your name?
Javon.
Javon. That's a terrific question, and one that's impossible for me to answer. It's very difficult. I'm going to give you what I think is the best answer. It's a little bit complicated, and I'm not sure it's right. But here's I need a chalkboard. Okay. See, forget the bottom circles, just the top circles. See this circle here, the alienated rights? That's the power we give to government. What do we give to government? That's the power we were just talking about. We give government the power to make laws saying when you have to be quiet, how fast you can drive, right? What you must pay your employees, things like that. How many fish you can, you got to get a fishing, think of licensing. Anything you need a license. That license is the way that government helps facilitate our rights. So a fishing license, I know this is a roundabout way, but I'll get there. A fishing license, why do we have fishing licenses? Well, because if everyone fished as much as they want, we'd run out of fish, right? Fishing licenses are actually designed by the government to facilitate the right of everyone to fish. That is, we the people, through our legislature, determine, hey, we want everyone to be able to fish, but if everyone fishes as much as they want, we'll drain the supply of fish in the lake. So we say you can take 2 fish, you can catch 3 fish a day, or whatever it is, these months of the year. The purpose of licensing is to make the availability of our right to fish regular. Regulation is not to limit our rights, but to facilitate our rights. Everyone with me there? Okay. And in that big circle, we give government authority over our natural rights that are part of the natural law. How to acquire property, another example is if we have a contract, right? I'm going to sell you lecture notes, you're going to buy them. How do we know when we have a contract? When we shake hands, when we have a verbal agreement? Well, we have the law to specify. Well, when you have a written agreement and you sign it on an official piece of paper, then you have a binding contract. That's all power we give to government, right? We usually use the word secular, but it's really civic. And now to get fancy here, that pertains to the natural moral law. There are things we don't give government power over. Our religious obligations, how we should pray. Is God 1 or 3? Are you to worship on Saturday or Sunday or some other day? Are you to follow these particularly religious dietary laws or not? those things pertain only to the divine law. Those are things that are in the unalienated rights. Those are things that are not contrary to reason, but above reason. That is, they're matters of revelation. We give to government to govern ourselves collectively matters that pertain to reason, human reason, things we can reason about together. We keep from government things that only pertain to revelation. God is a Trinity or not. Your question is, well, what belongs to the unalienated category, religion? It would be things that are above reason and subject only to revelation. That's where we say we retain authority over our beliefs and practices. We give to the common things that pertain to human reason. Pretty good? Okay, way in the back. Let me just follow up. There's one more, a little bit more of the question. So, when you're looking at, is this a religion or not? For constitutional purposes where government doesn't have authority, the way, or this new religion, is this religion? This answers the gentleman's first question of, well, we don't allow religions to say you can sacrifice your kids, right? Because the right to life, protection of life, is subject to human reason. We, the community, have authority over that, right? But whether the consecrated bread is the body of Christ or not, that's a matter of revelation which we, the people, don't give government authority to. So a new religion, it depends on the nature of the teaching and whether it's only a matter of revelation or a matter of reason. That's a fuller answer.
So you can practice as long as you don't violate the regulations. He said you can practice your religion as long as you don't violate the community's norms, and the community can make norms for those things only subject to reason, not to revelation. Okay? Okay, good. Sorry, ma'am, please.
Hi, my name is Mary, and I'm a community member. I'm really glad you have this slide back up because that's what I wanted to reference. Two things. First of all, the First Amendment, as a constitutional scholar, I don't need to tell you what the wording is, but it's establishment of, and you use the words from and for instead, which I found very interesting because that is one of the things that I believe creates the tribal response to the religion questions, first of all, is they're not reading the constitutional text. And establishment of religion is the wording, and that seems pretty clear to me. But the second thing is, I think, as a...
But wait, what is clear? What is an establishment of religion?
They're prohibited from establishing...
I know, but what is an establishment? That's not clear. If it was clear, we wouldn't have been arguing for it for the last 75 years. I mean, this is the problem with the Constitution. Not all of its provisions are clear. I mean, the president must be 35. We all kind of know what that is, right? I mean, I could spin out an interesting hypothetical right now saying, tell me your name again? Javon. Let's say Javon, I know you're not 34, but let's say he's 34. He's 34 on election day, but 35 on inauguration day. And the Constitution says to be eligible for president, you have to be 35. Can Javon run for president? On election day, he's 34. On inauguration day, he's 35. To be eligible for president, you must be 35. Can Javon run for president? We could spend the next half hour arguing about this. And that is the simplest, most textually evident proposition in the Constitution. Even the most simple, clear words, we know what 35 is, can be disputed. So very few words in the Constitution are self-evident. I haven't even let you ask your question, though,
Okay.
But go ahead.
So the second part of the question, because the first was really a comment, but this part of the question, again, as a constitutional scholar, you use your words very deliberately, obviously, and you use govern in the liberal management approach versus in the conservative, you use outweigh. And I'd like you to spend just a minute talking about the difference between the two words you've chosen there in those two circles?
I don't know. You might have given more thought to those words than I have.
Because I think that govern carries different weight and different implication around what the liberal agenda or liberal approach may be.
Maybe. It could be.
Versus
Tell me more.
outweigh.
That's interesting. Yeah.
Yeah, it seems more pejorative in a way, and more inflammatory, just saying. Whereas outweigh seems to favor that approach.
Well, but in the exemption approach, I mean, there's an asymmetry, though. Think of the playground example. The liberal approach says, if you're the religious group, you don't get the funds. The conservative approach is, you have a right to appeal for an exemption. You may or may not get it. You don't automatically get it. It's a case-by-case basis. So one is categorical where the other is not. So I actually think the terms, unintentionally to be honest, reflect the jurisprudential reality. Yeah. But that's not my view, that's just the nature of the jurisprudential tests. But thank you for I mean, that's an interesting and extraordinarily thoughtful reading of the slides.
We do have a question from Zoom that I'll read out for you.
Great.
How would you assess the role of public or special interest foundations which provide legal counsel pro bono in Supreme Court cases involving the religion clauses? Is it helpful for the founders' approach or a negative?
Well, none of them advance the founders' approach as a whole. I mean, almost every special interest law firm, pro bono or not, I mean, pro bono just means they're getting funded by benefactors, by wealthy people. There's someone who's advancing these interests, and those people are very wealthy. So let's not let pro bono in this area of law say, oh, we're just concerned with the common good. The answer is there's special interests on one side and special interests on the other, and the special interests fight each other. No one advances the whole agenda. Because this approach doesn't favor one side or other in our current political climate. Right? I mean, the underlying principle of justice in this approach is everyone should be treated equally. And right now, special interest law firms are just fighting for their clients to be treated unequally. This approach will never be adopted by special interest law firms. No one's going to hire me to advocate in the court of law this approach, because they would lose half the time. Right? But I'm not a lawyer, right? That's not what I do. Candidly, it's very emancipating, right? I mean, if you have clients, you have to advocate for your client. I just write books. I mean, it's also why I don't drive a very nice car. I mean, the business is not that good. Yeah. This approach could only be adopted by the people. It would never be adopted by special interests. Because there's not enough. Special interests there's special interests. I mean, I actually think this is for the common interest. Sorry, that sounds really self-serving. I mean, it's not my approach. It's not like I invented this stuff. This is our constitutional heritage. I mean, my job is only to try to understand it and explain it. I didn't come up with any of this. Yeah, please, yeah.
So Dr. Muñoz, we work with a lot of students who are trying to decide what areas of society they will go and lead in. And they talk a lot to us about justice, about climate disruption, about feeding the hungry and housing the poor, things of that nature, very specific legislative and policy kinds of issues. For a conversation like this, and we talked a little bit earlier today about the lack of knowledge people increasingly have about the Constitution, some of our founding documents, please make your argument for why it's important to be well-versed and well-schooled in some of these, in our founding, in order to address some of the issues and some of the areas that they're looking at today.
Yeah, well, no, I mean, thank you, first of all, for the question, but more generally for the wonderful conversation. And these questions are insightful and terrific. I mean, my first reaction, honestly, if you want to go feed the poor, feed the poor. You don't have to necessarily do legislative policy. I mean, maybe. Or maybe just go feed the poor. Or provide employment for the poor, which is especially useful to those looking for jobs. So we can do social justice in all sorts of ways. Legislative advocacy could be one, certainly. I'm not against that at all. So my first answer is realize that government does a lot, but it doesn't have to do everything, right? That, you know, we actually have an obligation to make our own communities better. We also need government to respect our rights, and government won't respect our rights if we don't understand them. Both what they are, but also what they're not. I mean, candidly, I think we have an exaggerated notion of what our rights are, right? And that we're too litigious. And that if we actually understood our rights better, we would demand less of our government and we demand more of ourselves, working privately but also working publicly together. And we'd be more open to compromise, right? We might disagree on how the common good is served or how government can help serve the poor or help with climate. We do that better still today. I mean, I can't believe I'm saying this, but we do that better today in our legislatures, as dysfunctional as Congress is, as opposed to our courts. And you know where we really do it better, actually, is it's not perfect, but in local government with citizens who live in the same community and who actually just talk to each other. We don't do enough talking to each other. I actually think most Americans are relatively sensible. Especially, like, you should go out and talk to people who you think you really disagree with. And I bet if you actually do that, my students find this all the time. Well, it's not that they don't disagree, but their disagreements are far less extreme than they think they are. So as my talk reflects, I'm much more about turning authority back to the people in a legislative capacity, because then it's a process of give and take. In the process of listening to people you disagree with, recognizing when they have good points, asserting your own points, finding compromise, that's what a political community is supposed to be about. And we just don't do that enough because we're too busy asserting all of our rights. At least that's where I see things right now. Not sure if that's the answers your question or the answer you're looking for, but that's kind of how I see things. You've been tremendously respectful and your question's tremendously good. Thank you very much.
Well, I want to thank Dr. Muñoz again for a really thought-provoking, challenging, and wonderful discussion this evening. Such a great way for us to observe Constitution Day and think more about our citizenship and our empowered citizenship as we leave this place. At the Hauenstein Center, we love theory and we love philosophy and we love to talk about these things, but we're also very much about action and what each of us can practically carry out in our daily lives. So we hope that you will join us in the exhibition hall after this for a bit of continued conversation over dessert. Find someone, ask a question, see if you agree, disagree, have some civil discourse around that, but we would invite you to engage. We'd also love to invite you back for future programming. We have an Open Minds Book Club later this month, a Wheelhouse Talk with Faye Richardson-Green. And of course, a host of more programming for the year, which you can always find at gvsu.edu/HC. I might also add that copies of Dr. Muñoz's book will be out and available for sale. And And I have one other membership. We have a lot of our members here today. If you're interested in supporting the work that we do, and our wonderful students like Yasmin, we certainly invite you to chat with us about how you can become more involved. Again, I thank you all for being here. Enjoy your evening, drive safe, and we'll see you at the next event. Thanks.